We have two cases before the court, excuse me, involving the same defendant, State of Ohio versus Kyle J. Smallwood, 22 CR, Kyle Joshua Smallwood, I should say, 22 CR 78 and 22 CR 110. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Dennis Kirk. You are Kyle Joshua Smallwood?
Correct.
All right. This matter is set for trial on February the 9th. And I think both of them are set at the same time. Has there been a motion filed for a joint trial?
I believe there has been, and it's been granted. Yes, okay. There has been.
I couldn't recall.
The motion, at least I found the motion, it was filed on November 4th.
When was it? November 4th?
The motion to consolidate was filed on November 4th, and looking to see if it was actually granted or not.
That was the day I found defendant competent, I believe. Okay. Well, there was more.
I'm not seeing that it was actually granted or if it was ruled on.
I don't think it has been, because I did not see an entry either. Let me look in the other file, make sure. No, I don't see it, so. All right. Now, is discovery complete on both sides?
It is by the state, Your Honor.
It is by the defense, Your Honor.
All right, and there are no pending pretrial motions, correct?
No, just the joint.
Other than the defense state's motion to join?
Just the state's motion to combine them. For the record, I did speak with my client about that, and he had no objection to having one trial.
Okay. All right, you're in agreement with that, Mr. Smallwood?
Correct.
All right. All right. Now, I did receive a communication dated the 16th from Mr. Smallwood. I didn't get it till late yesterday afternoon. 16th was a holiday, so I think it was brought up from the sheriff's office sometime after lunch yesterday, in which Mr. Smallwood has indicated that he wants to be his own attorney. Now, are you aware of that, Mr. Kirk?
I am aware of the request. Yeah, I've not seen the actual document, but on
Okay.
Monday I met with my client and he informed me of the same.
All right. So, Mr. Smallwood, would you like to address that incredibly bad idea?
I would like to address that, yes. I'm not saying that I want to completely go per se, but have him as co-counsel versus not have any counsel at all. Well,
the options are this under the law. You have an attorney to represent you, which is the smartest thing to do, or you can represent yourself. You can't be co-counsel. If you decide to represent yourself, the court does appoint a standby counsel, but that person doesn't sit at the table. They sit back away from you, and you have the right to consult with that person, but they don't participate. So you don't get to have your cake and eat it too, so to speak. And so that means that you would be in charge of your own defense, and you would be subject to the same rules that an attorney is. You don't get any breaks because you're a lay person. Now, you indicated that you're unhappy because you haven't got your discovery. Have you provided his discovery, Mr. Kirk?
Yes, I did provide the discovery.
No, I have not received a discovery.
You know how long ago?
I thought I did.
I've received no such thing at all.
So I could be wrong.
Did you ask him for that before you sent me a letter?
I did.
Okay.
I could be wrong. I thought I took it out early on in the case.
Okay.
I know there's been some trips to Twin Valley and things, but I can provide it again.
Yeah, okay. I mean, it's not that extensive. From what I read, this case is pretty straightforward. I think that the witnesses are clear from the, at least from what I read in the reports, in terms of the evaluation and the discovery. So I don't know, so, you know, he can give you that, but that, you know, he's your attorney, so, I mean, he's the one that's representing you, at least right now. So what do you think you're gonna do with that?
With the discovery?
Yeah.
I have no statements pertaining to, the victim, alleged victims. I have nothing to go on, basically, other than knowing what I'm charged with is not factual.
I will say I have gone over the facts of the case and summarized the
Well,
case.
he can provide that to you, but, you know, so the fact that you don't have it, I mean, you're not your own attorney at this point. He's your attorney. He has it. He thought he gave it to you. So it appears that, you know, would have been, you know, the good thing, the best thing to do would be to communicate with him about that. But he'll get that to you, obviously.
I've made futile attempts at that. I called his office and they hang up. My mom's called his office.
The only calls we get are collect phone calls from the jail. He's
Yeah,
not
they don't
called
take
on a-
collect phone calls
Yeah,
from
we
the
don't
jail.
take collect calls.
Nobody does it, I'm aware of.
I was under the understanding all the attorneys on the roster for the courts were free calls from the jail.
Well, I have no clue where that came from.
It's been that way for a long time.
News to me. Yeah, news to
I'll
me.
be, I mean, I've summarized the case for him. I went over it in great detail, but I'm more than happy to
Yeah.
print everything off again and make sure he has it in his possession.
Okay, well, that's, you go ahead and do that, okay. So, the question, Mr. Smallwood, you know, is, you know, we need to address this now, is whether you truly want to be your own attorney and represent yourself, and have Mr. Kirk as standby, meaning he would be available to give you advice during breaks and stuff. It's not going to be like where he's sitting there and you ask him every question or everything. He can't, you know, because that means that, you know, he's representing you. So, you know, that's not the way it works.
From a procedural aspect, I can adequately represent myself
Well, okay. Why do you think you can do that?
because I've been in trouble before.
Oh, okay. So that makes you an expert in
No, it doesn't
representing
make me an
people.
expert. My intellectual capacity is up to par.
Is what?
It's up to par.
Okay, because originally you were found not to be competent to stand trial.
Correct, and the reason I was found incompetent is because I made 3 specific statements. 1, that my attorney arrested me. 2, that the prosecuting attorney's father is a human trafficker. And 3, the last judge that sat on your bench had a 54-count indictment. And they told me I was crazy, that none of that happened. And in actuality, it all happened.
Well, I know the last one did. I don't know if it was 54 counts. It was a lot.
And Mr. Kirk was
I know your attorney didn't arrest you.
He has.
Well, attorneys don't have. Oh, okay. You mean back when he was a deputy?
Correct,
I got
correct.
you.
I recall him from my career in law enforcement. I do not recall personally arresting him. I mean, I don't know, but
Okay.
I've never used that in any way against
I got you.
him.
All right. All right. Well, when he arrested you, he wasn't his attorney, so technically that's not a correct statement. The correct statement would be, my attorney arrested me when he was a deputy, not when he was an attorney. So.
Correct. So
Okay,
it's
but anyway, so how far did you go in school?
12. I'm a commercial electrician, licensed.
You have a high school diploma?
Correct.
Have you done any studying since then?
What?
Post high school, after high school?
I'm a licensed commercial electrician.
Okay, teach you any law courses in that?
No.
Okay.
Civil classes are
Yeah.
remotely the same.
Well, here's the situation. You're charged with 2 counts of trespass and habitation when persons present or like to be present, which is felony of the 4th degree. And if convicted, each of those carry a possible sentence of at least 6 months minimum up to 18 months. And then in the 110 case, you're charged with menacing by stalking in count 2, and that's a 4th degree felony as well, and carries the same penalty. So you're talking about a possible prison term of somewhere between 6 months as a minimum and 18 months as a maximum on each count. That would be a range and possible of 6 months to 54 months in prison. And let's see, is there a PRC in this case?
Yes, there is, Your Honor.
How much is that?
It's filed, as of, on May 9th of 2022, there were 1,008 days remaining.
And 22?
Correct.
All right,
May
so-
9th of 22.
1,000, so we're somewhere around 700 approximately days, okay? So that means it could be 54 months plus whatever time's left on the post-release control, because it's more than 1 year, and under the law, if you're convicted of a new felony, then you can get a year or whatever time's left, whichever is more.
And that's the greater of the two, either the maximum amount of sanction time and or the maximum amount of probation time. Because my sanction time is 6 months,
No, the time on post-release control.
the probationary period.
It's not probation, it's post-release control.
Post-release control period.
Correct. And so that means that if you had 1,000 and some days back in May of last year, we're now about, that's been about 8 months, so 250 days or so would be off of that. You know, you'd be looking in excess of 700 days more if you're convicted. As far as lesser offenses, I suppose if there could potentially be a lesser offense of criminal trespass if there wasn't anybody present and you trespassed, if that's what the evidence showed, but there would have to be a reasonable possibility of that, so I don't know, wouldn't know until the evidence was presented whether or not that's a possibility. And in the menacing by stalking, I think that's, I don't know that there would be any,
I'm just gonna tell you right now, this is a mess. It's
Okay.
it's an inadequate mess
well,
from law enforcement perspective.
an inadequate mess.
It is a mess. It's a
And
word.
what would an
of war.
adequate mess be?
It's a word of a war of words. Basically,
Well,
they're
that's the
been
same
added-
case of every case is that way.
I understand.
You know, that's what the whole point is
I understand.
each of
The
them.
deci-
And don't interrupt me. But basically, the evidence is presented, and then, you know, the jury will make a decision as to what evidence they believe and what evidence they don't believe. But getting back to the point, I'm not here to listen to you argue about the case,
Right.
because that's what the trial would be for. But I'm just trying to explain to you what you're looking at. So you're looking at a potential of 54 months, plus another 750 days. That's 750 days is over 2 years. 54 months is 4.5 years. So you're looking at a potential maximum sentence of 6.5 years if you're convicted of everything, and sentenced to prison. And my policy is a person convicted of a felony while they're under post-release control, they get the post-release control, and that's consecutive by law. Now, there's also fines available of up to $5,000 on the two, or I'm sorry, $5,000 on the 4th degree, which is the stalking, and $2,500 on the, no, actually, they're all 4, so it's $5,000 each. So that's a possible $15,000 fine. Now, you understand those penalties?
I do, sir.
All right. Now, regarding possible defenses to this, this allegations, you know, there's been an evaluation on your mental state at the time, and there is no basis for an insanity plea, and so you cannot use any evidence of alleged mental state at the time as far as not being able to commit the offense because of that, so you would not be able to use that. I don't know what other defenses are, you know, other than arguing that it didn't happen, or I suppose possibly you know, the allegation is if you did by force, stealth, or deception, trespass. You know, force doesn't necessarily mean against a person, but it can be, the law says it can be opening a door, opening a window is sufficient force, or stealth, sneaking in, or deception, deceiving somebody to obtain admission. I don't think that that's, at least again from what I read in the mental report from the doctors, that doesn't seem to be an issue. So, and then the second count is in 110 is on the mental or menacing by stalking, is that you engage in a pattern of conduct. So I guess, you know, that would be a question of fact, and whether or not you caused someone to believe that you would commit physical harm to them, or if you caused mental distress to them. And, you know, again, that's That's not something that's real difficult to prove if someone's home and someone comes into their home without authority. If that's the evidence, that would probably be sufficient to cause mental distress. I know it'd be sufficient as a matter of law. Now, whether the jury believed it or not, that's up to them. I don't know. So, but what I'm trying to explain here is I don't know that that would be a defense. And then it also says that there was a trespass on lands where Kelsey Smallwood lives, is employed, or attends school. Okay. So I don't know what those, I don't recall that specific allegation. So I don't know what defenses are, not, it doesn't appear to be anything other than basically saying it's not true or I didn't do it. Are you thinking you have some other defenses that Mr. Kirk is not willing to assert?
The context with which the report was filed is inaccurate, period.
Well, that, again, that's a question of fact for the jury to decide.
Right, correct.
But I'm saying is, so I don't know what you're saying. I don't know what you mean by that. That is,
I mean, I obviously can't discuss that in the middle of the court, but what they're saying in the statements pertaining to, per se, the menacing by stalking, the specific incidents which incur a pattern of a pattern is, I was invited to these places.
well, that's a question. That's a disputed
Right,
question.
see, I mean,
Okay,
it's
all right, I
like,
got
so
you.
you're taking things out of context.
Okay, well, again, all right, so I understand that. So, and again, I'm sure your attorney's aware of that. Okay. So the issue here then, if you're wanting to represent yourself, which again, I strongly urge you not to do because I think it's a big mistake. There's an old saying that's been around for 100 years or more, back before we had women in the law, was a man who represents himself as a fool for a client. In today's world, it doesn't matter what the gender is. Anyone who represents themselves as a fool for a client because they're not objective. And so it's just not a good idea. But if you want to represent yourself, like I said, you're not going to be co-counsel. You'll have to be your own attorney. He'll be available to take breaks to consult about questions. If there's a legal issue up, he's not going to be involved in arguing on objections. He'll have no participation other than for you to ask him a question or something of that nature during breaks, or and I'll give you a reasonable time to do that. But it's not going to be every question. It's not going to be every minute. It's not going to be on every issue. You have to be your own attorney. That means you have to comply with the same rules of evidence an attorney does. You have to comply with the same rules of conduct that an attorney does. You have to comply with the same statutes that the attorney does. And you have no knowledge of any of those things, do you?
To a certain degree, yes.
Well, from courtroom experience?
Yes.
Okay. And again,
We're not
did you ever have a jury trial?
I have.
Yeah. And did you have an attorney?
I did, and it didn't work out very well.
You were found guilty.
Correct.
Okay. All right. And how long ago was that?
I believe it was 3 years ago.
What was it
4
for?
years ago. Correct.
What was it for?
Assault on a peace officer.
Okay. All right. Well, again, you have to comply, and if you sat through that, you saw some things that happened, and you have to comply with that. And you don't have any legal education. And have you ever read the rules of evidence?
To a certain degree.
Okay, which ones did you read?
4.
Huh?
Criminal Rule 4.
That's not a rule of evidence. See, that's what I'm talking about. That's a rule of procedure.
Oh, well, I meant the whole criminal rules as far as that goes.
Criminal rules are not the rules of evidence. Those are
The
different.
process with which we would have to incur or indicate rules of evidence and how they are admissible and what's admissible. I mean, that's kind of common sense to a certain degree.
No, not common sense. It's a law. The law
Well,
doesn't
it's
necessarily,
right.
it does not necessarily make common sense, but what you seem to think makes sense is not maybe, is usually not the case. But I deal with a lot of people who represent themselves in domestic cases and civil cases. And, they think that, if it makes sense to me, it ought to be admissible, and it's not.
No,
It's
and
got to be
I
in the rules of
understand, I
evidence.
understand we can't just come up here and talk about whatever we don't want to talk about. If it doesn't have or pertain to the specific incident at the specific time and et cetera, that it's something we can't address. Regardless of what my personal feelings are pertaining to that issue, if it's not specifically about what the charge is, when the charge happened, and who it involved, I understand from that conceptual perception
All right.
that I'm not allowed to talk about it.
Well, the other thing that lay people don't understand is that, and I run into this all the time, is that they think that when they ask questions, that's the time for them to argue or to testify on themselves.
Absolutely not. I want this to be cut and dry. I want it to be straight to the point. No one is going to know my case better than myself. And if there was any false pretenses pertaining to what I know, it's not what I feel. It's what I know to be true and what I know to be inaccurate in the statements from the police. There's a conflict there.
Well, again,
Once
what
we
you
cut
think
that-
you know is not necessarily admissible. And again, you're not an objective person. You are subjective. That means it's your freedom that's on the line and your future is on the line.
Correct.
So therefore, you're not in a position to step back and to objectively analyze what's said. Because from your perspective, you want one outcome in this case.
No,
obviously.
I mean,
You want one outcome. You want to be found not guilty. That's what you
I
want.
mean, to a certain degree, yes, that's a goal, obviously.
Well, I mean, I would think it'd be
It's the main
the
goal.
only goal.
objective, correct.
The only goal. Okay, and so because of that, you don't look at things the way attorneys will, the way the law does, the way a jury would. And so the reason I'm bringing this up is this. You may think that you'll be able to ask questions about things, but if they don't comply with rules of evidence, they're not going to be allowed to be admitted. You may think that you can testify to certain things, but if they're not within the rules of evidence, they will not be allowed to be admitted. You'll not be allowed to argue in terms of testimony. If you testify on your own behalf, you're not allowed to argue. You're allowed to testify as to facts. And I can tell you right now, that is the biggest problem with lay people representing themselves, is they don't testify, they argue. And there's a difference. Arguing is just what you said. I know this to be true. You don't get on the stand
Right,
and say,
I
I know this to be true. You get on the stand and say, this is what happened, that's what happened, this is what happened, this didn't happen. You don't get on there and argue. And
Correct.
again, I've seen it happen time and time again. And I've dealt with lay people representing themselves now for quite a few years and a lot of significant civil and domestic relations cases. And so the result of that is, because you're not educated in the law and you don't know the rules of evidence, because when I asked you about them, you said, well, you read the Criminal Rule 4, which is not a rule of evidence. You may end up not being able to present any defense. You may not be able to get any testimony in to the record that you think should be admitted, and probably some of it could be admitted if you had an attorney to ask it, because you won't be complying with the rules of evidence. And because you're not a lawyer, you don't get any extra help from the court. The court can't give you any help. You are presumed, if you want to make the mistake of representing yourself, of acting in the same way an attorney does. And so we may end up getting here and they'll put on their evidence and you try to cross-examine them and it's not proper and you get nothing out of it. And then you may get on the stand and want to try to testify, and if you don't testify under the rules, none of that comes in. It'll be disregarded, and it will mean that you don't get your case heard fairly because you don't know how to get it done. Now, I know sitting there you think because you've had an experience of being convicted once, that means that you have some knowledge. What it means, I think, in reality is you have a knowledge of an experience of having been convicted. Doesn't mean you know how to try and defend your case. And I know, talk is cheap. Everybody in the jail thinks that they know more than their attorneys. But we all know that to be, in the real world, we all know that not to be the case. And so I'm just telling you, you run a great risk, if you represent yourself, of ending up not getting anything out of cross-examination out that would help your case that an attorney could, and not being able to get evidence into the record on your own behalf. And it could end up very easily being that the only evidence is going to be in front of a jury that's admissible, that can be considered, is what the state put on against you. And so your lack of education and knowledge of the rules of evidence and other technical rules that apply during the trial in the criminal rules and the statutes would render you at a much greater risk for conviction than if you had an attorney. So, you understand that?
I do.
Okay. And you think that that's what you want to do?
It is.
So you want to waive your right to have counsel represent you in this matter? I mean, I've appointed Mr. Kirk, and by the way, you know, your motion said he works for me. He doesn't work for me. I appoint them. That's what the law requires. A judge has to appoint an attorney for someone who doesn't have the ability to hire one, and we have a rotation, and I go down that rotation and appoint attorneys as it comes up. But in any event, if you represent yourself, then you're giving up your right to have counsel represent you, and you'll be, like I said, making your own decisions. He'll be appointed to be standby counsel to consult with during breaks and, on certain things, but not every question, not every, he's not going to be sitting there acting as your co-counsel or second chair. That's not the way it'll work at all. And, you understand that?
I do. Is there any way I get an order from the court for my discovery?
I'm sorry?
Can I get an order from the court now for my...
Yeah, he's going to give it to you.
I have copies of what is marked, not marked counsel eyes only with me in the file. They do have staples in them, so I'll give them to the jail staff. That they don't allow staples, but I do have that. The only thing I would not be presenting today would be if the state has marked it as counsel eyes only.
Is there anything marked counsel only?
No, Your Honor.
All right, so then
And that should
everything
be-
that's been filed he can get.
Okay.
All right. Okay.
And this is victim statements, the whole, everything.
I'm sorry?
Victim statements, everything.
Whatever they have given him is what you get. Are the
anything
statements
else?
on the statements written or recorded? No, is there a thumb drive? or
There
something
is
like-
a CD. I would have to get somehow a copy to him of that, but I'm not sure.
Just
I
give him
think
your,
it's photos.
oh, that's photograph, yeah, you give that to him.
Go ahead and give that to him now. Okay.
Yeah, for the record, we'll show that he's giving,
Okay.
what
That's
is that
on-
marked as, Mr.?
This is one of the items provided by the state in 22 CR 78. It's a DVD or CD containing data.
Okay. And what's on that, Mr. King?
I'm trying to figure that out, Your Honor.
There are written statements.
Okay, are those included in the discovery?
Those are not in here yet, so I don't know if I need to keep a copy for my file, but I do have written statements here as well.
Yeah, why don't you go ahead and make copies of that and give it to him before you leave. Okay. All right, well, and the final thing I'll say to you, Mr. Smallwood, is again, the best example I could give, I guess, is that you're going to a gunfight with a knife. Represent yourself. And the gunslinger is the prosecutor, not you. It's a big mistake to do it. You increase the risk of being convicted greatly in the court's opinion and in experience. Again, one of the problems you'll have to be concerned about is the fact that you're emotionally involved because it's your life, and I understand that. But if you end up because of your frustration getting angry or whatever, that wouldn't impress the jury either.
Absolutely not.
One of the things that a jury does is observe body language, demeanor. Now there's a problem right there. You keep interrupting me. That's not going to happen. Okay? You're going to stop interrupting me. I'm trying to explain to you why this is probably the worst decision of your life. And you need to listen and not talk. So zip your mouth and open your ears. Okay? Now, what I'm telling you is, this is, I think, the worst decision that you could possibly make. But it's yours to make because the Supreme Court says that defendants have a constitutional right to be stupid and to be representing themselves, because 99.9% of the time it's the wrong thing. It's stupid. It's just not right. And I'm also going to tell you that if this is what you want to do, we're going to go ahead and I'll go ahead and allow it, because I think the record shows that you have the right to make this decision, even though it's the wrong one. You are obviously you're well spoken. You can talk well. You're intelligent, even though it doesn't. And again, don't confuse intelligence with good judgment, because they're not the same. Not at all. But in any event, you're going to be allowed to do that. But we're not going to get up to the day before the trial and say, well, now I've decided I want an attorney and I need a continuance, and that's not going to happen. But a standby counsel, you know, he would be able to step in. And at some point in the case, if you decide I'm in over my head, I want him to step in, then now he'll come and step in. But he's not going to be able to get a continuance. He'll have to do it right in the middle of things, and it'll go from there. The other thing is, at trial, you represent yourself, and you do all kinds of stuff that gets your, you know, that is not good for you and ends up causing you to be convicted in part. You can't appeal on the basis that, well, I was ineffective in representing myself, because ineffective assistance of counsel means an attorney. And if an attorney is not effective, you know, that can be grounds for an appeal. But if you represent yourself, that's not grounds for appeal. And you can't come back and say, well, I asked my standby attorney for advice and he gave me bad advice. No, because a standby attorney is just to answer questions and so forth, but they're not your, you know, they're not your attorney. So therefore, they're not, you can't come on appeal and say, my standby attorney gave me bad advice and therefore I received ineffective assistance of counsel, because you're waiving your right to counsel and saying I'm representing myself. And that's what I'm going to have you sign here, if that's what you really want to do.
It is.
Okay. So you don't want to think about that. You just want to go ahead and do it.
Correct.
All right.
And for the record, I'll go, before the jail leaves, I'll go into the office and make copies of what is not included here, so he has everything.
Okay. All right. So, Mr. Smallwood, I have here a waiver of counsel form, and I have the 2 case numbers and your name, and it says, and I, Kyle Joshua Smallwood, the defendant herein, being now in open court, fully understand under the laws of this state I have a right to legal representation, and I do hereby affirmatively waive my right to be represented by counsel. So, now, I said to you earlier, and I want to make sure it's not misleading or I didn't confuse you, is that you're waiving your right to counsel, but you can at any time change your mind. But like I said, it won't stop what's going to happen. You can't come in like a day or 2 before, say, I've decided I am over my head. I want Mr. Kirk to step in and take over, and then ask for a continuance, because we're going to go forward with the trial on February the 9th. You know, this case has been around a long time. It's not really that complicated, so we're going to try it. So Mr. Kirk will have to be, he'll be available, and he will be coming to all court hearings and so forth, if we have any more between now and then. But if you decide that you've made a mistake and you want him to represent you, you can revoke this waiver, but it won't be the basis for a continuance. And if it's in the middle of the trial, it won't be the basis for mistrial. And so if you get through the first witness and realize, man, I am so overmatched here, and you know, the judge isn't allowing the things I want to do because he says it don't comply with the rules of evidence, then you can't say, okay, yes, now, Judge, I realize I made a mistake. I want my attorney, I want an attorney again, and I want this case stopped and restarted over. It won't happen. You understand that?
I do.
All right. So this is a form, and if that's what you want to do, you want to waive your right to counsel. And again, I strongly urge you not to sign it, but you know, if you're determined to do this, then sign that, and we'll go forward.
Your Honor, I also have a plea rejection form. I know the court's not allowed to know the plea, but I have relayed the plea to him. The rejection form has it in writing.
Okay.
And is, would also present that to him as well at this time, that he is rejecting the plea offer.
All right. What's your, Mr. Kirk is there, Mr. Smallwood is, I don't want to know what the plea offer was, because I don't want there to be suggestion that that influenced any of my decision making. So that's just to show that you were informed of it, and there'll be a copy made for the prosecutor to keep the original, and you can have a copy, and Mr. Kirk can have a copy, so that if down the road, again, what has happened, the reason for that is because a number of years ago, about 10 or 12 years ago now, there was a case that went to Supreme Court where the attorney didn't tell the client, at least that was the allegation, about the plea offer, and the defendant said, well, if I'd known about that, I'd pled guilty and I wouldn't have gotten convicted of everything. And the Supreme Court said, you know, the evidence didn't show that the defendant was aware of it, so they reversed the conviction. So as a result of that, I put in this policy that I want the terms to be clear to each side, and then sign it. I don't get it. It only comes up if there's a post-conviction proceeding where that's an issue, then that document comes in as evidence. So you understand that?
I do.
And what you just signed, and again, I'm not going to get a copy of it, but what you just signed, that Mr. Kirk talked about, you rejected whatever the offer was from the state.
Correct.
All right. And you understood the offer?
I did.
Okay. All right. All right, well, then the record will show that the defendant has entered, or has executed the waiver of counsel form. And again, this document that I have before me you just signed, you understand, Mr. Smallwood, is you're indicating you want to waive the right to have counsel appointed for you and to represent you in this matter, and to proceed to represent yourself with Mr. Kirk being their standby legal advisor.
Correct.
All right. The court then will find that defendant has knowingly, intelligently, and voluntarily waived his right to counsel and wishes to proceed with self-representation, and so the court will allow that. Court will also appoint Mr. Kirk as standby counsel and legal advisor for the purposes of answering and giving advice as appropriate during the proceeding if requested, as well as in the event that the defendant decides that he can no longer represent himself or wishes to have an attorney, then Mr. Kirk would have to step in at that point, regardless of the situation. One other thing I should have said, and that is this, Mr. Smallwood, is that in the event that that happens, where you decide that you made a mistake and you want him to come in and represent you, you can't then later say, well, he didn't do a good job because he wasn't, he didn't perform because he wasn't adequately prepared or whatever, because again, you're going to be preparing your defense, not him. He can answer questions for you, whatever, but he's not going to be prepared. So again, if you do that, you assume the risk that if during the trial you ask him to step in to represent you, and the court I will authorize that if it happens, because you should have an attorney from the get-go, but you don't want one. But if that happens, you won't be able to use that as an argument either for ineffective assistance of counsel, because you're the one who created the issue. You understand that?
I did.
Okay, again, that doesn't change your decision.
No, Christy Wilkin wouldn't overturn anything in the appellate court. I'm sure that comes out of this court anyway.
Well, she's only one of 3 votes, or actually there's 4 of them, and there's only 3 on the panel, and she's not necessarily I don't know, I never know who's going to be on what panel, but, if that's true, I prefer to think it's because I'm always right. So.
Possibly.
Okay, I know that's not true, but, it's always nice to think that way. All right, now, so at this point, again, the record will show that from this point, or it's ordered then from this point forward, that the prosecutor representing the state assistant can communicate directly with the defendant, but you should also copy Mr. Kirk on anything that you do provide to the defendant, Mr. King. Also, this prosecutor is authorized to negotiate, should there be any further negotiations, directly with the defendant, and it'll be up to you, Mr. Smallwood, if they want to talk with you, or if you want to talk with them, you can contact them. It'll be up to you whether or not you want your legal advisor in on those sessions, not to participate, but just to ask questions. Again, from this point forward, if you do have any contact about possible negotiations, you'll be between you and the prosecutor's office. You can ask him questions, but he's not going to be talking with you or advocating for you, because he's not your attorney. He's just going to answer questions to you. He's your advisor, but not your advocate. You understand?
I do.
Okay. And I'm not sure if you're aware of this or not. When you were convicted, was that in this case, in this court?
It was.
Okay, it was jury trial in front of me?
Correct.
Okay, well, forgive me, I don't remember. But in any event, the rule that I have is that any plea agreements have to be done 14 days prior to trial, because when 14 days is when we send out our jury notices, and then people start changing their schedules, getting off at work, making arrangements for children, maybe changing appointments, and then or calling in here and asking to be excused. and making plans, and it just, there's a lot of people that are affected, and a lot of moving parts and a lot of expenses and costs that are incurred. So that's the reason I put that in. I don't, so don't expect to show up in the morning and try and say, you know what, I think I'd like to, enter a plea, and here's what I would like to do, or something like that. It'll be too late. On the day of trial, one of three things happens. Either the state goes forward and there's a trial, or you plead guilty to everything, or they dismiss everything. Those are the three possibilities. There's no possibility of a plea agreement, because once we have a jury here at 8:30, we're going to start as soon as we can with the trial.
I will be issued the roster for the jurors, correct?
You'll have yes, you'll be entitled to get a copy of that, and Mr. Strain, if you make a note to tell Mr. Reno that we'll send a copy of his of the jury list and questionnaires. Now, you're not permitted to contact those people, but you'll be entitled to review them. Those will have to be returned at the conclusion of the case. You can't keep copies of the questionnaires. Now, anything else from the state?
No, Your Honor.
And how many witnesses do you expect to have in this case? Getting back to my 14-day rule, that would mean January 26th, which would be next Thursday.
I would say roughly 6, give or take.
Six?
6, give or take.
All right, and you anticipate how
One
long?
day.
1 day.
One day.
All right. Okay. At this point, do you know how many witnesses you would have, Mr. Smallwood?
None.
None? Okay. And, you do have a right to testify on your own behalf, but you also have a right not to. And so, if you decide not to testify, the court does instruct the jury that they can't consider that for any purpose. But if you decide you're going to testify, I'll explain to you before you do that, that you have your right, and if not to testify, that if you want to testify on your own behalf, then you're giving that right up. So that'll be your choice. Okay.
Correct.
All right. Now, any other preliminary matters you would like to bring up at this point, Mr. Small?
Not this one.
All right. Well, if you have any, generally there's a deadline for pretrial motions of the final pretrial, but I'll give you until January 26th, which would be the 14 days prior to trial, to file any other motions that you think are appropriate. And if they appear to be appropriate, the court will schedule a hearing. If they're not permitted under the law, it's pretty clear, then I'll indicate that. Okay. Anything else you'd like to bring up?
Yes, sir.
All right. Thank you. Mr. Armentrout. Well, your attorney's Mr. Armentrout, isn't it, Mr. Reinhardt?
Yes, sir.
All right, well, I thought we had him there, but, wait a minute. Okay. Trying to figure out how to get everybody. Mr. Armentrout, do you happen to be there? Because I can't see you. Here we go, 5 more people entering the room. He must be in there. Okay, yeah, here he comes. All right, first case is State of Ohio versus Joshua J. Reinhardt, 22 CR 217. And you are Joshua Reinhardt, appearing from the Highland County Sheriff's Office?
Yes.
All right. This hearing is being conducted by Zoom. Mr. Reinhardt's attorney is William Armentrout, appearing from his office. Appearing on behalf of the state is Prosecuting Attorney Collins. The defendant is charged with grand theft of motor vehicle, 4th-degree felony, and his trial set for the 26th, I believe. And I have a proposed plea of guilty form here. Now, before I go forward, Mr. Armentrout, you and your client are both stipulating this hearing may be conducted by Zoom remotely rather than him appearing in person in the courtroom.
We are, Your Honor.
And you're okay with that, Mr. Reinhardt?
Yes.
All right. Since you're not in court next to your attorney, if at any point during this proceeding you would like to ask him a question, you just tell me, and then I can put you and him into a breakout room, and just the two of you will be talking to each other. No one else will be able to hear you or see you or know anything about it. The deputy will step out of the room. Okay?
Okay.
All right. Now, Mr. Reinhardt, I've been presented with a plea of guilty form which says you're going to plead guilty to the charge. This is, I'll hold it up to the camera for you so to show you, you recognize that form that has your name and case number and plea of guilty form.
Yes.
All right, this is a 3-page document. On page 3, there are signature lines, and about a fourth of the way down on the 3rd page is a sentence that says, I enter this plea voluntarily, and immediately below that, there's a signature line with signature of defendant below it, and it appears to me to be signature of Joshua Reinhardt. I'm going to hold that up to you, to the camera again, and ask you if that's your signature right below that sentence.
Yes, it is.
And when did you sign this, Mr. Reinhardt?
This morning.
And Mr. Armentrout go over that with you and explain everything to you and answer any questions before you signed it?
Yes.
Your Honor, we started working on this yesterday.
Okay.
So we-
All right. And did you understand that at the time you signed it, Mr. Reinhardt, that this was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And did you have enough time to fully consider this matter before making this decision?
Yes.
You feel you were rushed or pressured in any way into doing this?
No.
Did you enter into this agreement and sign it voluntarily?
Yes.
And this is still what you want to do?
Yes.
Right, now the agreement says on page 1 that you're going to plead guilty to the charge in the indictment, which is grand theft of motor vehicle under 2913.02A1, a 4th-degree felony. Further states that you understand the maximum penalty for that would be a minimum of 6 months up to a maximum of 18 months, any fine of $5,000. Do you understand that?
Yes.
Now, I believe you are facing a felony charge in Ross County, is that correct?
Yes.
All right. Other than that, are you facing any felony charges anywhere else?
No.
Now, if you should be convicted of this offense and the one in Ross County and sentenced to prison, then it is possible that the courts could order those sentences to be served consecutively, meaning one after the other. So you understand that?
Yes.
And are you currently on probation, community control, parole, or post-release control for a felony?
Parole.
Post-release control?
Yes.
All right. And how much time is left on that, do we know? let's see here. I might have this, a hand on it. Nope. You know how much time you have left on that, Mr. Reinhardt?
I think 1,068 days, you said?
How much?
1,068 days?
Okay, about 3 years or so. Okay.
It was filed back on November the 8th, Judge,
November the 8th, okay.
and it was 1,068 at that time.
Okay, so it'd be less than 1,000 now. Okay, yeah, I found it. 1,068, and so November would have been 22, and 31 would be 53, and today is 18. So that'd be 71 days off of that, so it'd be just under $1,000, about 997 days. And it will continue to decrease as the case goes on. But if you are sentenced to prison, then in addition to the prison term can be imposed for the offense, court could also then sentence you to serve the remaining number of days on your PRC, because the law says it can be either 1 year or whatever time's left, whichever is greater. In this case, the 997 days, or whatever it is at the time of sentencing, would be added to any sentence that you would receive from the court if you're sentenced to prison. You understand that?
Yeah.
All right, now, under the law, post-release control in this case is optional. And that means that if you were to be sent to prison and then serve the prison term, upon completion of that term, then it would be optional for the adult parole authority to put you under post-release control supervision for up to 2 years. They would, you'd be supervised by a parole officer under the terms they set, and if they determine that you had failed to comply during that period of time, then you could be returned to prison to serve an additional period of up to 9 months for any one violation, although there is a cap or maximum of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence could be imposed by the judge in the new case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time's left on that period of post-release control, whichever is greater. And if that occurred, that would be served consecutively a sentence in a new case. You understand that?
Yes.
All right, now under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, which means that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time the probation department felt that you had failed to comply, they would file a written notice of that with the court. You would get a copy, there would be a hearing, and you'd be entitled to have an attorney at that hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of between 6 and 18 months and fine you the $5,000. Do you understand that?
Yes.
I'm sorry?
Yes.
Okay. Now, the charge in this case, Mr. Reinhardt, alleges that on or about September 28, 2022 in Highland County, Ohio, you did, with purpose to deprive William Carpenter, the owner of property, not only obtain and exert control over the property to wit a 1997 Jeep Grand Cherokee, property being a motor vehicle is defined in ORC section 4501.01, without the consent of William Carpenter, the owner person authorized to give consent, in violation of section 2913.02A1 of the Ohio Revised Code. So that's the charge, the 4th degree felony of grand theft of motor vehicle with the penalties I've just described. Now, Mr. Reinhardt, do you understand the charge and possible penalties?
Yes.
Do you understand the nature of that charge, what it is the state said you did, when, where, and how they allege that you did it?
Yes.
And have you discussed that charge and the possible evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to get you to plead guilty here today?
No.
Now on page 2 there are 3 lines that are printed in bold and underlined, and I'll read those at this time. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control, and the defendant be referred to drug court. Defendant agrees to make restitution to William Carpenter in the amount of $237. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement you should get community control, once I've heard all the information, if I decide that's not the correct sentence, I could go ahead and sentence you to prison. Do you understand that?
Yes.
Mrs. Collins, as a state's consulted with the victim, alleged victim, Mr. Carpenter, any matter?
Yes, we've actually been in contact with him from the beginning. And yesterday spoke with him again when Mr. Armitra approached us and asked us for a different plea offer.
Okay, and he's in agreement.
And he, yes,
Okay. And Mr. Armentrout, the amount of restitution is agreed to, 237?
It is, Your Honor.
All right. Okay. Now, do you hold any license or certification from any state government agency that regulates any kind of an occupation in this state?
No.
All right? You have certain constitutional rights you must understand before I can accept a guilty plea from you. First, you have a right to have counsel in this matter, and I appointed Mr. Armentrout to represent you because you were unable to hire your own attorney. Now, he wasn't appointed simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide you don't want to do this, that you would rather defend the charge, he'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes.
Right now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Reinhardt, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After those 12 people are selected, the evidence will be presented, and they'd be instructed on the law. And then that 12-member jury would decide by unanimous verdict, meaning all 12 would have to agree, to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether the state proved your guilt. Do you understand that?
Yes.
Now, Mr. Reinhardt, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Right now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order that's called a subpoena, forces those people to come to court to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it during the proceedings, with one exception. If there's a jury trial and you don't testify, then the judge instructs that jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right. Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. What that means is that the burden of proof isn't on you to prove you're not guilty simply because you were indicted. In fact, under the law, you don't have to present any evidence at all on your own behalf. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
All right. Now, originally entered a plea of not guilty, and that plea denied the allegation in the indictment. Excuse me for a second. Would you get me a cup of coffee? Cured hazelnut or whatever. Thank you. All right. So, originally entered a plea of not guilty. The not guilty plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and that you committed that crime. And that plea waives, gives up all the rights that I've described for you today, except your right to have an attorney, which you always have no matter what your plea is. But with that exception, a plea of guilty waives or gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and to cross-examine through your attorney. Wage gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. A wage gives up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. And a wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, a wage gives up any right to file an appeal on any alleged violations of your rights you feel may have occurred up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes.
And are you a U.S. citizen?
Yes.
Right now, Mr. Reinhardt, do you have any questions about the charge or the possible penalties?
No.
You understand them?
Yes.
Do you have any questions about the plea agreement?
No, I just need drug help, Your Honor. You know,
Okay, well, yeah, we'll talk about that later, but right now, you understand the plea agreement?
Yes.
All right. Now, do you have any questions about the constitutional rights I've explained to you?
No.
You understand those?
Yes.
All right, do you understand, do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes.
No, do you have any questions first?
No.
Okay, now, do you understand them?
Yes.
Okay. Now, is there anything you'd like to speak to Mr. Armentrout about before we go any further, Mr. Reinhardt?
No.
All right, do you have any questions about anything I've explained to you here this afternoon?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the
Yes.
terms of this agreement that we've just gone over?
Yes.
All right, then as to the charge, which alleges that on or about September 28, 2022 in Highland County, Ohio, you did with purpose deprive William Carpenter, the owner of property, knowingly obtain or exert control over said property, to wit, a 1997 Jeep Grand Cherokee, thank you. Property being a motor vehicle is defined in ORC section 4501.01 without the consent of William Carpenter, the owner or person authorized to give consent. In violation of section 2913.02A1, the charge of grand theft of motor vehicle, a fourth-degree felony, carrying a possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, thank you. The court finds on this date, open court, defendant was advised of all of his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal 11. The pleas accepted, order filed. Defendant is found guilty of the charge. The court will refer the matter for a pre-sentence investigation, and I'll also refer the matter to the drug court for evaluation and discussion as to whether you wish to apply for that program, Mr. Reinhardt. The court doesn't order people into drug court. The court will accept applications and then rule on whether the person should be admitted, because it's a different program and you have to request to be in it voluntarily, not ordered. And it's based on a lot of different things. And Miss Sturgill there is on the screen. She'll go over that with you. We will set this matter for hearing, or sentencing hearing, I should say, on February 16th at 1:00 p.m. Bond will be continued. Ms. Sturgill, will you be able to get out there today to see him before they take him back? He's going to go back to Ross County. You're muted.
Yes, I'll make sure we get him a packet.
Okay, all right. Yeah, so Deputy, if you would make sure that they keep him there this afternoon so they can, probation can get out to see him and he can take him back tomorrow then.
Yes, sir.
All right, thank you. Anything further from counsel?
No, Your Honor.
All right. Next case then would be she's appearing by Zoom. Are you Kelly Marie Humphrey there at the probation department?
Yes.
Okay. It's case number 22 CR 133 State of Ohio versus Kelly Humphrey. This hearing is being conducted by Zoom. Ms. Humphrey is appearing from the probation department. Her attorney is Sarah Barger, appearing by Zoom. Also, prosecuting attorney Collins. There had previously been, well, the defendant is charged with theft of fifth-degree felony. There have been, looks like, submitted stipulated questions for intervention that were signed today. It has a date and signed by all parties and council. And then I have the motion for intervention in lieu of conviction that has been filed requesting an evaluation and consideration for intervention program. Ms. Humphrey, the court's going to order that you be evaluated for substance abuse issues by, if you're not in treatment already, you'll be referred to an evaluation. Where do you live?
I am living in Medway, but my address is going to be changing.
To where?
Judge, before you order some, I'm
was
sorry, I didn't mean to interrupt.
Go ahead.
No, I'm asking you a question. Where would you be living?
My address is going to be changing to 719 Cypress Drive, but
And what town is that in?
That's in Greene.
In Greene County?
But yes, but I talked to Full Circle yesterday, which is a inpatient, like a sober living house, and they told me that they would do my assessment and everything today, and that they would get me housing.
All right, well, you'll have to make sure that you keep in touch with the probation department, Mr. Arjima, so that they can decide that. Ms. Collins, you just seem to be really antsy about wanting to say something. Go ahead.
I really do, because I don't want the court to waste time with all of this. Ms. Humphrey has not reported to probation. We just found out about this. Mr. Arajima just sent us a text message. Has not reported to probation since her arraignment.
Yes, I know. I have that.
Today, when she did report, I'll advise the court that there is likely going to be a presentation of a tampering with evidence case based on what she did at the probation department today when she did report.
All right, well,
Which
under the law, I'm required to have a hearing. And so,
Okay.
you know, the law changed. It used to be I could deny these summarily, just because I didn't feel like it, but now I have to conduct a hearing and follow the criteria. So I'm going to go ahead and order the evaluation, and we will set this out for hearing beyond the next grand jury. Would you anticipate that if there is a case, it will go to the next grand jury?
As soon as the probation office gets me the report.
All right. That will, so I'll go ahead and order the intervention evaluation. We will set the hearing for February the 16th at 2 p.m.
Am I able to speak?
Your Honor,
Pardon me?
I'm gonna be out of the state February 16th.
Oh, okay. Well, then let's make it,
I'll be back on the 20th, which is President's Day.
we'll just set it for March the 8th at 8 a.m. Or, I'm sorry, 9 a.m. So you'll need to keep in touch with probation, Ms. Humphrey.
I had a question. The only reason why I haven't been able to check in completely, like come up here, is because it's literally an hour.
Kelly.
Yes.
Don't stop.
It's
talking.
literally what?
Okay. Never mind. I'm sorry.
Okay. Yeah, I didn't hear you, but your attorney, I think, said not to speak anymore. You know, the problem, you know, getting yourself to hearings and reporting is your problem. It's not the judge's problem. And, you know, I tell people that if they have a difficulty, where did she go? Oh, there's the screen just flipped. That if you have difficulty with transport, that I have the answer to that. It is free room and board at the Hardin County Jail until your next court date. So you need to be compliant, because if you want to be given intervention in lieu of conviction, you know, and again, I don't know if that's going to happen or not, based on what might happen in another case if it happens. But in any event, your behavior while you're waiting trial, if you're convicted, has a bearing on the court's decision of sentencing, and it would also have a bearing on whether the court feels that you're amenable to intervention in lieu of conviction if that is possible under the law. Again, I don't know, because I don't know what's going to happen. The prosecutor's got to evaluate and decide whether they're going to present another charge. All right, so make sure you report and give them a release of information to this the Greene County agency. If you go into treatments, you need to make sure you give them the release of information so they can be aware of that and get the information into the report that's going to be submitted to the court. Anything further, counsel?
No, Your Honor.
All right, thank you. All right. Okay. She's not in custody, is she?
No, she's on.
Okay. Oh, there she is. Okay, I see her. I thought she was in custody. All right. The next one we'll need from the jail would be, let's see. Aaron Tumbleson. Do you have Aaron Tumbleson there?
Yes, Your Honor, we do.
Okay, he'll be the next one from the jail. All right. Case number 22 CR 171. State of Ohio versus Bobby Renee Foster. Are you Bobby Renee Foster, appearing on the screen, marked Bobby Foster?
Yes.
All right, Ms. Foster, this hearing has been conducted by Zoom. Ms. Foster's attorney is Sarah Barger. She's present from her office. From the prosecutor's office is Prosecutor Collins. The defendant's charged with aggravated possession of methamphetamine, aggravated possession of drugs, both 5th-degree felonies. This is I believe, a first pretrial, and it was continued from a different date, as I recall. Final pretrial will be on the 1st, and jury trial is on the 23rd. Now, I see the discovery's been provided by both parties. Is it complete as far as counsel knows?
It is from the state.
Yes, Your Honor.
All right. Do you anticipate any pretrial motions, Ms. Barger?
Motion for intervention in lieu at this time.
Okay. And, okay, there's a written plea offer then, is that correct?
That is
Yes.
correct.
Okay, all right. All right, then as soon as you get that, the court will, board evaluation, set that for hearing. I do note that I received a fax yesterday afternoon from probation indicated that you were referred to FRS, Ms. Foster, and missed your assessment last week. So, you have to have this assessment for determination of your situation, whether or not you're eligible for intervention in lieu of conviction. So make sure that you keep your
I
appointment.
have it set up for tomorrow at 3 o'clock.
All right, make sure that you sign a waiver as well.
Yes,
So that, release of information, I should say, that's what they call it now. All right, anything further from
Clear.
counsel in this case?
No, Your Honor.
All right, thank you. All right, Aaron Tumbleson. All right, case number 22 CR 173.
He's not in jail, Judge. That's him at the probation department.
Oh, okay. My notes say I guess it doesn't. He's not in jail. All right. So, deputy, the next person I thought he was in jail. He's not. So it looks like Miss Haynes will be the next one up from jail. All right. So, State of Ohio versus Aaron Tumbleson, 22 CR 173. Present for the state is Prosecuting Attorney Collins. Present on behalf of the defendant is Attorney William Armentrout. And you're Aaron Tumbleson, appearing there from the HCPD screen?
Yes, sir, I am.
All right. This hearing is being conducted by Zoom. Mr. Tumbleson's charged with 1 count of aggravated possession of a fentanyl-related compound. This is a first pretrial. Final pretrial is the 15th of February, and trial's March the 20th. Looks like we have had discovery provided by the state. Mr. Armentrout, did you file yours yet?
No, I haven't.
All right, we'll be due by final pretrial. Do you anticipate any pretrial motions?
No.
Okay, has there been a written plea offer?
There has, my client's not aware of it. He needs to get hold of me, Your Honor.
Okay. All right, Mr. Tumbleson, you're there at the probation department. Why don't you walk down to Mr. Armentrout's office after you get done there and make an appointment to see him?
Okay.
Because he needs to discuss the case with you. All right, anything further, counsel?
No, Your Honor.
All right, we'll see you on the 1st of February, or 15th of February, Mr. Tumbleson. Thank you.
All right, thank you.
Case number 22 CR206. Are you Katrina A. Haynes appearing there from the jail?
Yes, sir.
All right, this hearing is being conducted by Zoom. Ms. Haynes appearing from the jail as indicated. Her attorney is Sarah Barger appearing from her office, and then appearing from the prosecutor's office is Prosecuting Attorney Collins. Defendant is charged with trespass and habitation when a person is present or likely to be present, a 4th-degree felony. This is a first pretrial was continued from the 4th. Final pretrial is set on the 1st of February, and the trial is set on the 21st of February. Now, Ms. Haynes, the court has received a plea of guilty form, which indicates that you're going to withdraw your not guilty plea and plead guilty to the charge. Now, this document is a 3-page document that the prosecutor's office has prepared from their computer, and I'm going to hold this up to you to make sure you recognize it. So do you recognize this in the camera, the plea with your case name, your case number and your name?
Yes, sir.
All right, and on page 3, there are some signature lines. About a third of the way down, there is a line that says, I enter this plea voluntarily. Below that appears to be a signature from January 6, 23. And is that your signature there on that document?
Yes, sir.
And so it was back a couple of weeks ago that you signed this document, is that correct?
Yes.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes, sir.
And did Ms. Barger go over that with you and explain everything to you, answer any questions you had before you signed it?
Yes, sir.
And did you think you had enough time to fully consider that matter before making this decision?
Yes, sir.
And is this what you still want to do almost 2 weeks later?
Yes, sir.
All right. Now the agreements, did you enter into this agreement voluntarily, by the way?
Yes, sir.
All right, now the agreement states that you are going to withdraw your not guilty plea, plead guilty to the charge of trespass and habitation when a person is present or likely to be present under 2911.12B of the Ohio Revised Code, a 4th-degree felony. Further states that you understand that the maximum penalty for that could be 18 months in prison, a minimum of 6 months if prison terms imposed. There's a fine available of up to $5,000. Do you understand that?
Yes, sir.
Now, are you facing any felony charges, any other jurisdiction?
No, sir.
And are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Okay.
Not for felony.
All right. Now, under the law, if you're convicted of this offense, Ms. Haynes, it is possible that the adult parole authority, once you complete your sentence, may put you under post-release control supervision for a period of up to 2 years. They don't have to, but it's up to them. It's optional. If they do, you'll be supervised on the terms they set by a parole officer, and if during that period of time they determine that you failed to comply, they can return you to prison and make you serve an additional period of up to, in this case, half of your prison term for one or more violations. But if you were convicted of a new felony, then in addition, whatever sentence a judge in a new case could impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, under the law, the court's not required to sentence you to prison for this offense. I could impose what's called non-prison or community control sanctions, meaning instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time, the probation department felt that you were not complying, then the court would set a hearing on that matter after getting a written notice from the probation department. You'd get a copy of that notice so you'd know what the allegations are. You would have a hearing, and you would be entitled to have an attorney to represent you. And if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of 6 to 18 months and fine you $5,000. You understand that?
Yes, sir.
Right now, the charge in this case alleges that on or about September 18, 2022 in Highland County, Ohio, you did by force, stealth, or deception knowingly trespass in the residence at 129 Bell Street, Hillsborough, the permanent or temporary habitation of any person, when a person other than an accomplice of the offender is present or likely to be present, in violation of section 2911.12b of the revised code. So that's the charge which I've just explained to you, and the 4th degree felony. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
And you understand the possible penalties for this offense?
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible defenses you might try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Now, on page 2, there are some lines that are printed in bold and underlined, and then one of them has been stricken out to indicate to the court it doesn't apply. So I'll read you the remainder that does. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 12 months incarceration. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the recommendation of the parties is not binding on the court because the judge is the one who has the duty to impose sentence, not the parties. So if you plead guilty, once I've heard all the information submitted, I don't have to follow that recommendation. I can impose any sentence between 6 and 18 months. I can impose community control. Do you understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any trade or occupation in this state?
No, sir.
All right. You have certain constitutional rights you must understand before I can accept your plea. First, you have a right to counsel. Ms. Barger is appointed to represent you, not for the purpose of working the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide you don't want to plead guilty, you'll still have counsel representing you to defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, and then they'd be instructed on the law. And then that jury would have to decide by unanimous verdict, meaning all 12 of them would have to agree, as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a quarter bench trial. That means instead of a jury hearing the evidence, it would be the judge who heard the evidence, applied the law, and decided whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Haynes, you have a right to confront witnesses against you and to cross-examine them through your attorney, which means that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is probably to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Right now, in the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. That is, if there's a jury trial you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, in the Constitution, you have a right to, or you have a presumption of innocence, which means you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right. Now, and by the way, I forgot to do this, I think, at the beginning, but Ms. Barger, you and your client are both agreeing to this hearing being conducted by Zoom rather than in person in the courtroom?
We are, Your Honor.
All right, and I didn't tell you earlier, Ms. Haynes, but if you have any questions you need to ask your attorney, would like to talk to her about anything, since you're not in the courtroom, just tell me and I can stop and put you and her into a breakout room for that purpose. You understand that?
Yes, sir.
Okay. Now, under the law, as I said, you're presumed innocent, so I'm just going to go back to make sure I covered that. But you're presumed innocent, which means you don't have to put on any evidence at all. It's up to the state to prove your guilt by proof beyond a reasonable doubt on every element of the offense charged at a trial, and you're not required to put on any evidence at all. You understand that?
Yes, sir.
Okay. Now, originally you pled not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described for you. Now, if you change your plea today from guilty to, or not guilty to guilty, that is the opposite of not guilty plea. Guilty plea will admit the allegations in the indictment, admit that they're a crime, you committed that crime, and that plea waives, gives up all the rights I've explained for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty waives, gives up the right to a jury or court trial, waives, gives up the right to confront witnesses against you and cross-examine them through your attorney, waives, gives up your right to cross-examine the state's witnesses in open court through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Waives, gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence under the certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing intervening file. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Haynes?
Yes, sir.
Do you have any questions about the charge and possible penalties?
No, sir.
You understand them?
Yes.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what the consequences that'll be if you enter here today?
No, sir.
You understand?
Yes.
Now, is there anything you need to speak to your attorney about before we go any further?
No, sir.
All right, do you have any questions about anything I'll explain to you here today?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the plea agreement that we just went over?
Yes, sir.
Then as to the charge which alleges that on or about September 18, 2022 in Highland County, Ohio, that you did by force, stealth, or deception knowingly trespass in the residence at 129 Bell Street, Hillsborough, permanent or temporary habitation of any person, when a person other than an accomplice of the offender is present or likely to be present, in violation of section 2911.12b of the Ohio Revised Code, the charge of trespass in a habitation when a person is present or likely to be present, fourth degree felony, carrying possible prison term between 6 and 18 months, fine of $2,500. How do you plead?
Guilty, sir.
All right. Now, the court finds that on this day in open court, defendants advised of all their constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendant is found guilty. Now, I see there's a jointly recommended sentence, but there is, there is not a request for PSI. That's been stricken out. Okay. So, based on that, the court will go ahead and proceed with sentencing. Anything from the state?
Yes, Your Honor, we would ask the court to follow the joint recommended sentence, would note the defendant's prior criminal history, which is substantial. Would additionally note that she committed the crime that she has now pled guilty to while she was, I believe, while she was on the drug courts, in the drug court docket. And so based on all of that, we would ask, additionally, we have notified or been in contact with the victim who approves this plea. There is no restitution. Based on all of that, we would ask the court to follow the joint recommendation. Thank you.
All right, Ms. Barger?
Your Honor, I've met with my client a few times and had multiple conversations about this case. She's taking responsibility. She just wants to move forward in her life and do better. She's ready to proceed with sentencing. We just ask that you follow the recommended sentences. It is in the plea agreement.
All right. Ms. Haynes, anything that you would like to say?
I would just like to apologize for my actions in this situation.
All right. Well, Ms. Haynes, you appear to be healthy today and much better situation than you were last year when this all happened. I know you were in the drug court and you had gone through just about every program that was possible to have. You had graduated, and the only reason you were still on paper was because you hadn't paid your cost. And based upon the guidelines set down for us by the Supreme Court, Ohio were not to punish people solely for the non-payment of cost. And so, based upon that, I terminated you unsuccessfully. Well, actually, I just terminated you from community control because you'd completed the drug court curriculum. But it appears that, and I have to say I probably know as much about you as any defendant that has appeared in front of me in the last few years because of your participation in drug court and the number of ups and downs you had. And the big thing that appears to me is your mental health is still is a problem. Now, right now you seem to be in pretty good shape. What I would hope is that when you complete this sentence that I'm about to impose, that you, number one, make sure that you address that while you're incarcerated, and number two, even more importantly, once you're out, that you address it, because that's going to seem to be the problem. You use drugs when your mental health isn't good, and there when you were compliant, not taking drugs, you were taking addressing your mental health issues, you did great. And I know you can do it, but if you don't acknowledge that, it's up to you. The court can't make you do it. Judges can't fix anybody; they have to fix themselves. And we've tried to help you, but at this point, it is time for responsibility to be recognized, and you have done that by pleading guilty. So the court acknowledges that. So based upon that, the court hereby sentences you to the Ohio State Reformatory for Women at Marysville, Ohio, for a period of 12 months. According to what I have from the Sheriff's Department, you are accredited for time, in this case, from September 27th to the 4th of October of last year, and then from December 6th till December 17th I'm sorry, none, there was zero for that. You were on the county court then. And then you had 32 days from December 17th until today. Does that sound right then?
Yes, sir.
Okay. So the court grants you the 40 days of jail time credit. Now, upon completion...
Well, I think it would have been more than 40.
Yeah, but you weren't in on this case, though. The other cases...
From the 17th, from December 17th until today, so that would be...
Yeah, 32 days, yeah.
And then also, it was like October 4th to November 2nd.
Well, that time was on a municipal court case. I'm sorry,
It was this
court
case. I just hadn't been bound over yet.
Well, that's what I have from the sheriff's office. Ms. Barger, if you want to contact the sheriff and see if there's a discrepancy there, I'll be glad, and if it is incorrect. But right now, what I have here is that those are the dates that all the time between October 4 and 12/6 12/17 were applied to municipal court case number CRA 2200622 and county court case number CRB 2200253. So that's what I'm going on at this point. If that is incorrect,
Judge,
then we can do that.
CRA is a felony number, so it's incorrect.
Okay? Well, we'll contact the sheriffs and see what we can get, and see if there's anything different on that.
When I spoke
No, wait
with
a
them,
minute, wait a
it was
minute.
closer to.
No, hold on. Actually, that is correct. That case number, I misread it. That case number from 9/27 to 10/4 was the felony case, and there are 8 days out of municipal court. So that is correct. They don't have anything down for the period of 10/4 to 12/6, so we'll have to ask about that. 12/6 to 12/17 says it's a county court case, but there's no mention of the time between 10/4 and 12/7 to 12/6. So I'll contact the sheriff's department, and we'll find out what's going on that. Now, upon completion of this prison sentence, Ms. Haynes, it is possible that the Adult Parole Authority will put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer on the terms they set. And if during that period of time they determine that you have not complied, they can return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in a new case can impose upon you, the judge is also authorized to sentence you, in this case, to an additional period of a year, whatever time left on the period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. You're also ordered to pay the court costs with judgment, grant, execution is ordered. If you fail to do that, then the court could order you, clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
No, Your Honor.
All right. You're remanded to custody, Ms. Haynes, and again, we'll check on the jail time credit. Thank you.
Okay, thank you.
All right. All right, are you Jason Bond there at the jail?
Yes, sir.
All right, this is case number 22 CR 246, State of Ohio versus Jason Bond. Mr. Bond's appearing from the jail. This hearing is being conducted by Zoom. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. The defendant is charged with aggravated possession of methamphetamine, a third-degree felony. I believe this is a first pretrial. Final pretrial set for the 15th of February. Trial date is set for March the 20th. Now, see, the discovery has been provided by the state. Have you provided yours yet, Mr. Wagner?
I have not, Your Honor. If I may, we've already been out to see Jason a couple times. We've gone through the discovery. We've got a plea form signed. We've set up the assessment with Ms. Sturgill, and I'll get the appointment with Ms. Oyer to set up a plea in the PSI, Your Honor.
All right. Anything else then to discuss?
No, sir.
Okay, Your Honor.
All right, thank you. All right, then Jeremiah Jackson from the jail, please. Well, okay, whoever's on the Samsung phone, mute yourself there, because the man in the black shirt, well, I can mute him. All right. I don't have this file. Okay, wait a minute. Cutler. Yeah, it should be. Well, I'm looking.
So, I know, it's like,
Yeah, I got a red folder, but that's all I have. Oh, okay. All right. Case number 22 CR 225, State of Ohio versus Jeremiah Jackson. Are you Jeremiah? Looks, I'm sorry, CR 251. Are you Jeremiah Jackson appearing there from the jail?
Yes, Your Honor.
All right. Mr. Jackson's attorney is Jacob Wagner. This hearing is being conducted by Zoom. He's preparing from his office. Preparing from the prosecutor's office is Prosecuting Attorney Collins. I only have a red folder. They haven't been able to locate Mr. Jackson's file for some reason. So, Ms. Collins, you want to tell me what he's charged with for the record?
Sure. He is charged with grand theft of a firearm and breaking and entering for trespassing on property to commit a felony.
All right, this is the first pretrial, I believe, right?
It is a first pretrial. Final pretrial is February 1st, and the jury trial is February 21st.
All right, and as a state provided discovery?
The state has provided discovery, Your Honor.
Participating in pretrial motions, Mr. Wagner?
I do not, sir.
All right, well, your discovery will be due by the final pretrial. And has there been a written plea offer?
I believe we've discussed a written plea offer. However, we have not provided that to Mr. Wagner because we have not gotten approval from the victims yet.
Okay. All right, any other matters to be discussed at this time then?
No, sir.
All right, and we'll see you back
No, Your
here
Honor.
in your next pretrial, Mr. Jackson. Thank you. Ben, we need to find this file. It's missing. Yeah.
Your Honor, may I address the court?
She was furloughed in between those days, apparently.
Gotcha. Okay. I'm sorry, Mr. Wagner?
May I just, I have a couple guys that are out. I didn't know if any clients were, or any defendants were in the courtroom.
We're not off the record yet on this case. Is there anything else about this case?
No, sir.
Okay. (22 CR 184, State of Ohio versus Daniel J. Witt. This hearing is being conducted by Zoom. Mr. Witt's appearing by Zoom. His attorney is Sarah Barger, appearing from her office, appearing on behalf of the state as Prosecuting Attorney Collins. And Ms. Barger, do you and your client both waive the defendant's presence in the court and agree to appearance by Zoom?
Yes, Your Honor.
All right. The defendant has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred for a pre-sentence report. The court did receive that. This hearing was originally set back in, I think, the 4th and was continued until today. Have each of the attorneys had an opportunity to review a summary?
Yes, Your Honor.
All right.
Yes, Your Honor.
All right. Anything from the state?
Only what's contained in the plea agreement, Your Honor.
Ms. Barger?
What is contained in the plea agreement, Your Honor?
All right, Mr. Witt, anything you would like to say?
Not at this moment, sir.
Now, are you still at the FRS, or are you at home now?
I'm back. I'm still going to FRS at the moment.
Okay, you're doing outpatient.
Yes, sir.
Okay, all right. All right, well, it's a judgment order of the court that you be sentenced to a period of 3 years of community control under the supervision of the probation department as follows. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements that you make to the probation department or answers you give to questions about your supervision. You're to keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with anyone or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not permitted, because of your conviction, to purchase, own, or use, or have under your control any firearm, ammunition, dangerous ordnance. And if you do that, you could be subject to prosecution for an additional felony under both federal and state laws. It's also a condition you have none of those items or any other weapons of any type while you're under community control. You're not permitted to purchase, possess, use, or have under control any controlled substance, a drug of abuse, CBD oil, kratom, or any variant or analog of a controlled substance that has effects that are similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer them or prepare them for administration or use, unless you have lawful prescription for both the device or item and the substance. And you must provide a copy of that within 24 hours of its receipt to your supervising officer. You're to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage or be present in any places where they're sold or being consumed, even if it's otherwise lawful. You may not associate with anyone who's a co-defendant in this case, or any person that has a criminal record, a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a violation of these conditions, unless approved in writing by your supervising officer. That applies to any family members, may fall within that definition unless you were living with them immediately prior to the commission of this offense. After the date of this order, you're not permitted to marry, establish cohabitation in a common law type of relationship with another person without prior written permission. You must report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law, not later than the next business day after that occurs. If you are you're also, if you are referred by the probation department for an evaluation assessment for any type of therapy, treatment, or any other programming, you'll submit to that. And if there is a recommendation for treatment, then you are to enroll in and follow that during the pendency of this action. Now, you'll also be required to pay the court costs and make payment arrangements to do that. You'll be required to perform 400 hours of community service, and you'll be given credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until it is paid in full. Now, you're also required to successfully complete your substance use disorder treatment and aftercare through FRS. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant by any officer of the probation department at any time, as well as a search of your person, your residence, vehicles owned by you, used by you, or any other property place where you are found at any time by any of those officers. There'll be no fine. There'll be no driving suspension imposed. Now, in the event that the probation department feels that you have not complied with these conditions, they will serve a written notice on you and give a copy of that, file a copy with the court, and there will be a hearing set. You'll be entitled to have an attorney. If the
Okay, Tuesday at 1:30.
all right.
Okay, that's fine.
We'll have to mute that person there. All right. Now, in the event that they allege that you have failed to comply, then the court will have a hearing after you've been notified of that. You'll be entitled to have a hearing. And if the outcome, and have an attorney represent you, and if the outcome of that hearing is that you have failed to comply, then the court at that time could revoke your community control and then sentence you to prison for a period of 12 months and fine you $2,500. If that occurs, upon completion of that sentence, the Adult Parole Authority may place you under what's called post-release control for a period of up to 2 years. They don't have to, it's optional. If they do, you'll be supervised under the terms they set. If they determine that you've failed to comply, they can return you to prison to serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, in addition to whatever sentence the judge in the new felony could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, Mr. Witt, this completes your case. You're no longer under pretrial supervision, but you will need to contact the probation department to set up your appointment for your intake into the felony supervision program. So, Mr. Fulton, should he contact, or do you have an appointment set up already, Mr. Witt?
I do not.
Okay, well then contact him as soon as we get off the, go ahead and sign off after this, call the probation department and get your appointment set up.
Will do.
All right, thank you. You can go ahead and sign off.
All right, thanks, sir.
All right, case number 22CR238, State of Ohio versus Dylan Tate Campbell. You are Dylan Tate Campbell, appearing on the screen marked Dylan Campbell.
Yes, sir.
All right, this hearing is being conducted by Zoom. This is a first pretrial. Mr. Campbell's attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, his prosecuting attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial and final pretrial set on the 1st. Trial is on the 23rd. I see the state's provided discovery. Have you provided your discovery yet, Ms. Barger?
No, Your Honor. I am meeting with Mr. Campbell next week, and it will be.
All right. Do you anticipate any pretrial motions?
Not at this time.
And have you received a written plea offer yet?
Yes, I have.
Is the defendant aware of that?
Yes, he is.
All right. Any other matters then to be discussed at this time?
No, Your Honor.
All right. Then we'll see you in your next pretrial, Mr. Campbell. You can go ahead and sign off.
Yes, sir. Thank you.
All right. State of Ohio versus Gregory Wallace. All right, this is case number 22CR221, State of Ohio versus Gregory Wallace. You're Gregory Wallace, appearing on the screen marked Greg Wallace.
Yes, Your Honor.
All right, this hearing is being conducted by Zoom. This is a pretrial. The defendant's attorney is Jacob Wagner, appearing from his office, appearing from the state's, for the prosecutor's office of Prosecutor Collins. The defendant is charged with having a weapon under disability and a forfeiture. This is a first pretrial. Final pretrial is the 15th of February. Trial is the 20th of March. All right, I see the state has provided discovery, and have you filed your discovery yet, Mr. Wagner?
We've not, Your Honor.
Okay. Did you do by final pretrial? Have you anticipated any pretrial motions?
I do not, sir.
And have you received a written plea offer yet?
I have, Your Honor. I've not given it to Greg. He did stop in the office prior to us getting it. If he can just swing back by, we can get a copy of it to him.
All right. Mr. Wallace, I need to get in touch with your attorney then. All right. Anything else from counsel?
State your
No,
honor.
sir.
All right. Then you can go ahead and sign off, Mr. Wallace, and make arrangements to get to your attorney's office. Okay, thank you.
All right, thank you, Your Honor.
All right. 22 CR 222, State of Ohio versus Dallas James Toll. You're Dallas James Toll, appearing on the screens as Dallas Toll.
Yes, sir.
All right, this hearing is pre-trial being conducted by Zoom. Mr. Toll's attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant's charged with assault on a peace officer, 4th-degree felony. Matter set for trial on March the 9th. The next pre-trial is February 15. See, the state provided discovery. Have you provided your discovery yet, Mr. Wagner?
No, sir.
All right, it'll be due by the final pre-trial. Do you anticipate any pre-trial motions?
No, sir.
And has there been a written plea offer provided?
There has, Your Honor.
All right, is your client aware of it?
He is not, Your Honor. I've not, at least I personally have not spoken to Dallas since the arraignment. He may have called the office, but I've not spoken to him.
All right, well, Mr. Toll, you need to get in touch with Mr. Wagner so he can discuss your case. All right.
Yes, sir.
Anything further on this case?
There is, yes, Your Honor, from the state. Mr. Toll failed to appear for a juvenile court hearing. He has a warrant for his arrest.
All right. Well, Mr. Toll, I don't know what it was about, but you
Child
just heard what she said. So that's a civil warrant. But if there's a warrant out for you, they're going to take you into custody. So you must get in touch with the court downstairs and arrange to turn yourself in so that that can get taken care of. All right. You can go ahead and sign off then.
Yes, sir.
All right. Okay, Mr. Queen, you'll need to unmute your phone there. Should be a little microphone with an arrow through it in red.
There we go.
All right. Case number 22 CR 242, State of Ohio versus Jeremy Levi Queen. You are Jeremy Levi Queen.
Yes, Your Honor.
All right. This hearing is a pre-trial being conducted by Zoom, and Mr. Queen is appearing on his phone from his vehicle, which I would note is not moving. And his attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, prosecuting attorney Collins. Defendant charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial, and a final pretrial set on the 15th, and trial set for March the 6th. I see the state's provided discovery and a bill of particulars. And Mr. Armentrout, have you provided discovery yet?
No.
All right, it'll be due by the final pretrial. Do you anticipate any pretrial motions?
No, Your Honor, the state is offering treatment in lieu here, but I've not spoken with Mr. Quinn yet, so he needs to get hold of my office immediately.
All right.
Okay, I can do.
All right, so as soon as you sign off here in a moment, call Mr. Armentrout's office to get an appointment.
Okay, and I'm getting ready to head to work too.
Okay.
If I may, Your Honor, Jeremy, what is a good phone number for you?
740-701-8530.
All right, call my office as soon as you can. That's all, Your Honor.
All right.
I will call you tomorrow morning.
All right, that'll be good. All right, you go ahead and sign off and get to work then.
All right, thank you, Your Honor.
State of Ohio versus Zindell Russell. Case number 22 CR 230, State of Ohio versus Zindell Russell. You are Zindell Russell, appearing there from the probation department?
Yes.
All right. This is a pretrial being conducted by Zoom. Mr. Zindell, or Mr. Russell, I should say, the attorney is Dennis Kirk. He's appearing from his office via Zoom, and appearing for the state's prosecuting attorney Collins. Defendant's charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial, and a final pretrial set for the 15th, and trial set for the 6th. You see that the state has provided discovery in this matter, and Mr. Kirk, have you provided your discovery yet?
I have not yet, Your Honor. I need Mr. Russell to contact my office so we can discuss the case.
All right. Do you anticipate any pretrial motions?
Not at this time.
All right. Has there been a written plea offer that you've received?
I have not been able to relay it to my client, though.
All right, Mr. Russell, since you're there in the probation department, when you get done, just walk down the street to Mr. Kirk's office and get an appointment to see him. You know where it's at?
No, I'm not.
Down across from White's Bakery. You know where that is?
No, I'm not
All right.
familiar with Hillsborough.
Okay, well, when you go out of the door, the front of the building you're in now, turn left.
All right.
Walk up to town to the light, cross the street, go down the street to the next light, cross the light, it's across the street, right on the corner, directly across from White's Bakery. It's 2 blocks, a block and a half from where you are.
All right.
All right, go directly there. You can go ahead and sign off now and leave. Thank you.
All right, thank you.
There was noise coming from your device. Can you unmute yourself? There should be a red microphone with a line through it. Click on that. All right, there you go. All right. Case number 22 CR 244, State of Ohio versus Marshall Smith. Getting some feedback there on your device there, Mr. Smith, but might want to turn it down a little bit. All right, the defendant's charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a pretrial being conducted by Zoom. His trial date is the 15th of February, or I'm sorry, pretrial, 15th of February. Trial date's March the 9th. See, the state's provided discovery, and have you filed your discovery yet, Mr. Kirk?
Not yet, Your Honor.
All right, well, it'll be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time.
All right, has there been a written plea offer received?
There has. I need my client to contact my office so that we can discuss it.
Okay. All right, are there any other matters then to come before the court?
No, Your Honor.
All right, Mr. Smith, as soon as you hang up, give Mr. Smith, Mr. Kirk's office a call so you can make an appointment to go ahead and discuss your case with him.
Okay.
All right?
All right.
Thank you. You can just go ahead and sign off.
All right, thank you.
All right, case number 22 CR 245, State of Ohio versus Sylvia Cutler. This is a Zoom hearing being conducted, a pretrial, I should say. Appearing from her office is Attorney Danielle Witt on behalf of the defendant. Appearing on behalf of the state is Prosecuting Attorney Collins. The defendant is not present. This matter was set for Zoom at 2:15. No, I'm sorry. Yeah, 2:15 p.m. I do have a statement from the probation department that she has failed to report since December 21st. Spoke to her on January 12th by phone and advised her to report on the 17th, which would have been yesterday, and she did not show at that time. Mr. Arjima is on the call. Have you received any had any further contact with Ms. Cutler? He must be out of the room. All right. Ms. Witt, have you heard from your client? Ms. Witt is frozen. Can you hear me all right, Miss?
Yeah,
All right.
there she's back.
There
I'm
you
sorry.
are. All right, Miss Witt, we had you frozen there in a not real flattering pose, I'm afraid to say. Oh, there it went again. There, you're back. So you're breaking up a little bit. Can you hear me all right?
Yes, I can now. I think I have bad internet connection or something.
Yeah, probably does. Okay. All right, have you heard from your client?
No, I have not.
All right, well, did you hear me that she's not here in court and is not reported?
Okay, yes.
All right. Well, court then will order a capious to issue for her arrest, and we'll put the case on the active docket until she is taken into custody.
Okay, thank you.
All right, thank you. All right, that leaves a 3. All right.
Good afternoon, Your Honor.
Good afternoon. Go ahead and put us on record. All right, this is case number 22 CR 226, State of Ohio versus Nathaniel Applegate. And you are Nathaniel Applegate, appearing there with your attorney from his office.
Judge, we can't hear you. You're muted.
Okay, are you Nathaniel Applegate appearing from your attorney's office there?
Yes, sir, I am.
All right, and Mr. Parker is appearing with his client. This is a Zoom pretrial. Defendant is charged with possession of hashish, a third-degree felony. This is a first pretrial. The trial is, the next pretrial is set for the 15th of February, and then trial set for March the 23rd. Now, I see that the prosecutor provided a bill of particulars and a compliance with discovery. You've received that, Mr. Parker?
Yes, Your Honor, I received that by mail yesterday.
All right. Oh, thank you. Well, yours will be due by the final pretrial. Do you anticipate any pretrial motions?
Your Honor, I've reviewed paper discovery. I need to receive the video from the state. Possible motions to suppress on the search, but I'll make that decision once I see the video. I'll be picking it up from the state tomorrow when I'm out in front of Your Honor on another case.
All right. Well, that'll be due by your final pretrial date. And has there been a written plea offer yet?
There has been.
been.
All right. Is your client aware of that?
He has, Your Honor.
All right. Are there any other matters we need to discuss then at this time?
No, Your
Not too
Honor.
much, Your Honor.
All right. The next pretrial will be by Zoom as well. We'll send an invitation on that. And if there are any pretrial motions, then we'll set a hearing date at the final pretrial.
Thank you, Your Honor.
All right. Thank you. I believe that's it.